addition, I would call the court's attention to the transcript that we filed at the last hearing, which was a week ago, where we attached the entire testimony of Katie Pridemore during the trial. In putting all that together, one can see that beginning apparently in the fall of 2012, shortly after Judge Hunter took the bench, the prosecutor's office began to put together a dossier, and I'll call it that, because what they were doing is outlining any situations in which they disagreed with any activity that Judge Hunter did as a judge, any findings that they disagreed with in reports, and they even highlighted and called it different things. A particular report that was referred to by Ms. Pridemore during her testimony was one that was listed refusal to set dates or make decisions, also known as Twilight Zone cases. It goes on further with other editorial comments that were made, and according to Ms. Pridemore's testimony during the course of the trial, she indicated that this was a report that she was putting together that she had been requested by the Chief Justice of the Ohio Supreme Court to make. If that in fact was the caliber and the manner in which reports were made to the Chief Justice of the Ohio Supreme Court, with the editorialized comments upon which it was made, I find very interesting and somewhat out of the normal and a very unusual event. Ms. Pridemore indicated that she had been requested by the Ohio Supreme Court to put together this report, and so that it was being made for purposes of really finding activity upon which to do something in a manner to retaliate and to bring some type of action against Judge Hunter, the purpose of which I believe was clearly designed to try to find a way to get her off the bench.
The Supreme Court was asking Ms. Pridemore did this. How is that prosecutorial vindictive?
Well, I believe why would the Chief Justice on their own decide to go do that without the inference that can be made as circumstantial evidence that there had to be some communication with the Ohio Supreme Court relative to Judge Hunter. I mean, this was very shortly after she took the bench, very shortly after the period of time that there had been the successful challenge to the vote that had occurred that earlier fall, the year before, and when she was elected to the bench. And I believe it's an indication of the spirit upon which her term of office commenced in May of 2012. I believe that putting it together and putting it in the light, it was obviously a very biased opinion that was being sent to the Ohio Supreme Court. It was designed and when combined with other activities that were going on, the comments being made to the public, the fact that while at the same time doing an investigation of Judge Hunter, when various activities and matters came up upon which she needed counsel to represent her in her official capacity before the appellate courts in this county, the same office that was conducting an investigation and to do a report, it seems to me that it was an open conflict of interest that should have been expressed. And I believe that they should not have been handling any cases upon which Judge Hunter was listed as a defendant. And I believe there were numerous litigations that were filed by the newspapers because of their disagreement of Judge Hunter's attempt to protect the name and privacy of juveniles, which was really and truthfully consistent with the philosophy and the spirit of juvenile court. Juvenile court is a court designed to protect the individual children who were brought before it. And one of the things that was a constant battle with the media was the coverage upon which the local media was giving of cases that were before the court and with the disclosures that were being made. And it seemed to be a battle over, ultimately, the issue of whether the identity of the individual would be shown by showing their face and their identification marks upon which the papers and the media could make that public. And all Judge Hunter was attempting to do was to protect that interest of children and the privacy rights that I think the spirit of the juvenile code was designed to protect. We have additionally attached in the original motion for vindictive prosecution have put in evidence of matters that were publicly disclosed, comments being made by the same office that was required under the statutes to defend Judge Hunter. And ultimately, ultimately, at some point, after some disagreements had taken place, and the absolute refusal of a prosecutor to tender to the court for in-camera inspections documents in making comments, and we've had some of the transcript of that hearing with the court that Ms. Pridemore made to the court, that I find that was done specifically in a rude manner, it was inconsistent with the respect that should be given to a court. And when contempt was found of the young prosecutor who refused to turn over the documents for the in-camera inspection, the court made a finding of contempt that ultimately she did let it go. But I think that it was soon after that all this attention started to go, that ultimately then impanels a grand jury as a result of the disagreements with the prosecutor's office, the consistency with the conflict of interest that seemed to originate as a result of the battle that occurred in the election results, and ultimately an indictment on matters that were being done by other people in the court. The use of the credit card was consistently being used to pay for conferences that were not for travel. They found, and they combed it, and they found B1 section and used it to bring an indictment. Not only did they allege misuse of the credit card, they started to claim theft of government money, which was totally, there was nothing hidden by it. It was used because of the feeling that the court needed to be protected. No one appeared at the Court of Appeals hearings that related to the 527 appeal. And the court, even though there was a request for counsel, counsel was appointed, who apparently never met with Judge Hunter, and then no responses were given, and by default, those prosumiendo cases were ultimately decided by our Court of Appeals within the time frame. Judge Hunter believed, for the protection of the credibility of the court itself, of the juvenile court, filed notices of appeal that ultimately was then participated in by Ms. Branch in filing a brief with the Ohio Supreme Court, and ultimately all the prosecuendo cases were dismissed by the Ohio Supreme Court. Ohio Supreme Court accepted the filing by Judge Hunter. They accepted the payment by the credit card that was issued by Fifth Third Bank to the Hamilton County Juvenile Court, and that was consistent with the spirit upon which that credit card had been used by other members of the juvenile court staff. So that we believe that, that was found. They didn't just do it in one count to say misuse of a credit card. They broke it down into component parts, overlapping the same facts, instead of just being one count, to make it much more dramatic, made it into 4 or 5 counts. Followed with a subsequent indictment later in January of 2014, then again filed another indictment in March of 2015. Vindictive prosecution is a matter that is something that can be handled in a pretrial motion. I believe that we have submitted sufficient information to the court to realize that there was an underlying motive in this case to bring about the downfall of Judge Hunter. And it was started from the time, for whatever reasons that bitterness may have been established, it continued to carry over, and it's continued even up through today. Every article that comes out, public comments that are made, are always made in a derogatory fashion, only to bring the ultimate goal of the downfall of Judge Hunter. I think it's uncalled for. In my years of practice, I've never seen, with the vindictiveness that's been instigated against her, against any other judge, and I've been in practice for a very long time. I've gone through many administrations of courts, many different makeups of the Ohio Supreme Court, our Court of Appeals for the First Appellate District, as well as the Common Pleas Court here. In fact, my early years of practice were in the Juvenile Court of Hamilton County. As I was at that time, magistrates were called referees. I spent 5 years as a referee under His Honor, now deceased Judge Schwartz. And I know that the effort upon which he made to protect individual children that were charged with various acts of delinquency and other matters, to keep their privacy, to talk about cases without identification, never labeled the children as being involved, have been criticized the court for letting people out and then claiming that they had not been let out on bond, which is a constitutional right to everybody, is entitled to it, except in capital offenses. and then being accused of being the cause of someone getting injured or hurt as a result of a court acting in the fashion upon which they did for the protection of children. And I know the efforts to which he went to protect both the integrity of the juvenile court and to protect the children that came before the court. We submit to the court, we've cited case law in our memorandum that has been filed, supported the dismissal. I believe that the attachments that we have filed to the court for your review, and if one looks through the testimony of Ms. Pridemore, as she testified before the court in this case, quoting from page 1641 of the transcript of the proceedings of the trial that occurred in this matter that ended and resulted in virtually all the counts being where the jury could not reach a verdict. I'll quote. This is the testimony of Ms. Pridemore. There are a couple of reasons. First of all, I was directed by the Ohio Supreme Court to watch those dockets and give this information on the judge, anything that it was. It goes on further in her testimony where she later says, because the Ohio Supreme Court told me to start monitoring several cases, and I didn't see any other cases that had happened. I don't know why they picked out particularly two cases that were somewhat, one was, I believe, totally kind of no different than many others. It was a carrying a concealed weapons case upon which an individual was interrogated after he had been handcuffed and was being led to a police car, and it seemed to me that the granting of a motion to suppress him based upon a Miranda violation was entirely appropriate. But Ms. Pridemore goes on at page 1719 of the transcript that my personal observations was that your client, heading into the prosecutor's office, every time we turned around, she was doing something. She did not trust us, she did not like us. We had already appealed 5 other cases before I won't mention the young man's name. My only logical conclusion is that she was trying to prevent the state of Ohio from appealing, especially after I looked her straight in the eye and defiantly explained to her that I wanted to appeal the July 23rd decision. And so it was clearly apparent to the court, or to the prosecutor's office, that an appeal was going to be filed. What is interesting is that there's a letter that we've gotten, that we've attached as exhibit from the Ohio Supreme Court that indicates clearly that Ms. Pridemore was never retained, and in fact an inference can be made, and it is made, that she was not contacted by the Ohio Supreme Court, or if she was, I find it interesting that that's the same court upon which affidavits of bias or for recusal were filed with, that were making findings after having had some previous indication and designating somebody to kind of be the telltale and to look into activities because there was disagreement with the findings.
You're going to do that, but I didn't understand the last sentence at all.
Well, I find it interesting that people that are ruling on matters that have been formed, not just with this court, but with the prior court that was with us on affidavits of asking in support of the request to have the court recuse itself from the county. I find interesting that the court is already having some pre-knowledge in the Supreme Court. I'm not talking about anything about with this court, but that the Supreme Court would be making rulings by someone who designated somebody to do an investigation of someone else. I believe that one would think that there would be a neutral, unbiased approach to handling any motion that's before it, not seeking information on the outside on one hand and then ruling on matters that may be involved.
So you're saying the Chief Justice?
I'm not saying any, I'm only building an inference as we come. Because I believe that, Your Honor, I believe that our whole system is designed on the idea of giving the appearance of fairness and justice.
Absolutely.
And I think and so that brings in the call.
You suggest, I find it interesting, that in some way the Chief Justice was not fair and just. That's something that perhaps I'm obligated to send this transcript to the Chief Justice
It's fine. I'm not making an accusation. I'm just merely saying that many inferences can be drawn. That it seems to be, if in fact there was an investigation that had been indicated by the Ohio Supreme Court, and I'm basing that upon the testimony of Ms. Pridemore at the hearing on her testimony before this court. She, in addition to that comment, made the following, that I have like a 50-page document that I had to give to the Ohio Supreme Court, documenting case after case, after case, after case, of how she would basically run the juvenile court through the mud. I was in her courtroom day in and day out, and how she treated the state of Ohio, holding prosecutors in contempt and dismissing cases for no good reason. I mean, I can document if you have a good 5 hours. I brought it with me if you want to see it, but with me to be able to tell every fact I mean we were be here a while. I can go case by case about how she would treat the cases, how she would ignore law, how the First District would reverse her plenty of times, at least 5 or 6, 7, 8, how they have said that she just ignored the law and tramples on the law, and I have seen it firsthand. That is a report that is being given by someone who's gone to that court, who has given a report that has highlighted on it the twilight zone and matters such as that. And if that is the case, I'm troubled by it. I don't know that, where all this involvement of everybody, and then to be followed, and then to follow after this report is made, to follow and impanel special grand juries, as special prosecutors appointed with all that's gone on to indicate that somehow some design idea came, let's get her off the bench. The way to do it is let's bring criminal charges against her. For matters that other people did, there's no absolute evidence at all that came out in that trial that showed that anything was deliberately backdated for the purposes of depriving anyone of their right of appeal.
You're not going to argue the trial.
I'm not arguing.
A long history here. We're still looking for the motion to dismiss indictment. That's what we're here for.
That's right, and I'm trying to bring forth to the court the indications upon which the inference of vindictive prosecution can be brought up.
So witness that testified that works for the Hamilton County Prosecutor's Office. The Hamilton County Prosecutor's Office is not the group, the organization of people that are prosecuting this case. So I'm not making a connection about selective prosecution. I sure don't see the prosecutorial vindictiveness here when those two gentlemen are the prosecutors on this case. Maybe I'm missing something, but go ahead.
Well, I believe that it comes about by, I'm putting, why wasn't it recommended to the presiding judge when recommendations were made to bring somebody out from outside our particular system? There are retired assistant U.S. attorneys in this community that could have been appointed who were independent, unaffiliated in any way with anything of practicing within this county. They were not consulted, nor were their names apparently recommended to be brought in to handle this case. And I think that when you put it all together, you can't be blind to it. I think there's enough inferences to be made that there was no way that there was not going to be an indictment returned in this particular case. And I believe that it is not supported by the evidence that came up, and I don't think it's impermissible to bring before the court that which came up in the original trial that ended up in the hung jury on the numerous counts that there was the hung jury on. Because I think that certainly it was targeted. They looked at, they ignored what other people within the court and charges that were made by them. They ignored other matters that went on, and the 30127, and to divide it up like it did in the multiplicity accounts that it resulted in. The more the merrier. It's like throw it up on the wall. Some of it's going to stick. And that's what I believe happened here. And I don't believe that it's supported in the law or the facts that this was an independent, unbiased grand jury that returned these indictments. And therefore, I believe it should be dismissed.
Just on the last comment, you said the grand jury was biased.
I believe that they were biased. I think that they were, what instructions, the court won't let us see what instructions were given to the grand jury as to what the law was and how the interpretations and the instructions that were given and the perimeters of that. And with that only one has to make speculations.
So these 7, 9 people that returned this indictment
They followed instructions that followed what evidence was presented to them. And what those instructions may have said or may not have said would ultimately determine how the grand jury would react and reflect those facts. And that's why we've asked, and the court has already denied us, having the transcript of what instructions were given to the grand jury.
That's just for the record, but because there's not been shown any particular item.
Do that. There was just one other item, if I could, to clear the record. I do have an exchange of emails, and I'll give a copy to Mr. Croswell. It clearly indicates, at least in this email response, that the Ohio Supreme Court, although I drew an inference from the testimony of Ms. Pridemore, that there had been a request for it. I just want to add this as an additional exhibit. It's an email that indicates that the Supreme Court, in response to the public records request, said that they had not authorized or requested any investigation.
First of all, I was directed by the Ohio Supreme Court to watch those dockets and to give them information on the judge.